I think it's a bit misplaced to think that if somebody asks you to do a job and they're going to pay you to do that job, and you say, yes, I'm going to do it, the fact that there's no written formal contract doesn't mean there's no contract. There's a contract. The basic contract is somebody asks somebody else to do something, and another person promises to do it, and then there's an exchange, and usually money in order to cover that. That's a contract. So it doesn't matter that there's no written contract. There's no formal JCT, NEC form of contract or FAC. The fact that somebody's asked you to do something and you've agreed to do a bit of work means there's a contract in place.
Hello everybody, Gavin Coyle here. I'm the Gaffer podcast. Brilliant guest today, Martin Burns, who deals in dispute and resolution for construction companies and companies in general, but specifically for construction companies, obviously a massive risk in terms of trying to get paid, who's paying you, when are they going to pay you, why didn't they pay you, all the arguments, all the stuff that comes afterwards. Well, Martin's going to discuss how you can put models into your business to try and protect yourself, number one, but also if the crisis does hit, I want to be talking to Martin and his team, and I want to understand how they can help me navigate around this whole trying to get paid scenario. So with that, Martin, I'm delighted to have you on board. Welcome to I'm the Gaffer. Tell me a bit about yourself and how did you get to where you are today?
Oh, thank you, Gavin. How much time have we got? How did I get to where I am today? I work for the Royal Institution of Chartered Surveyors, or RSCS, and I've actually been there 34 years, and I discovered recently that I'm the longest serving member of staff at RSCS anywhere in the world. So I've been hanging around working for this organisation for 34 years. And in all of that time, I've been involved in the area of dispute resolution. A bit of a misnomer, really, because my job's about helping businesses, people, organisations, and indeed governments as well, to avoid, manage and resolve disputes so that they don't end up going to court. So though I've worked for the Chartered Surveyors for all that time, I'm not a surveyor myself. I'm actually a lawyer, barrister by qualification, and I'm one of those lawyers I think many lawyers despise because I'm constantly spending my time encouraging people not to go to lawyers because it costs too much, and if you end up in court, it takes forever to resolve whatever issue you're trying to deal with. And not only that, but the amount of money you spend on court cases is always going to be far more money than you're chasing after, particularly if you're a smaller business. I don't mean that disparagingly, because small businesses, on the face of it, would be chasing after relatively small sums, but for them, it's not small. It's very important.
It's their everything.
It's their everything, yeah. It's their next job. It's their food on the table. So my job is not only helping the big boys, it's also helping smaller businesses to find ways to get paid when they're entitled to be paid. And this is what dispute resolution is about. Dispute resolution is answering questions about whether somebody's entitled to be paid under a contract, and if so, making sure they get paid as quickly as possible.
I'm interested to find out, if I don't have a contract in place, and I took the word of the person that gave me the job, do I still have any sort of legal sort of argument or not? I know you don't want to get involved with the legality side of things, but should I say, well, I'm not going to contact Martin because Martin's just going to tell me, you're stupid. Why did you enter into something that you've no formality to?
Well, I think it's a bit misplaced to think that if somebody asks you to do a job and they're going to pay you to do that job, and you say, yes, I'm going to do it, the fact that there's no written formal contract doesn't mean there's no contract. There's a contract. A basic contract is somebody asks somebody else to do something, and another person promises to do it, and then there's an exchange, and usually money in order to cover that. That's a contract. So I think the first bit of my answer to your question there, Gavin, is to say, well, it doesn't matter that there's no written contract. There's no formal, JCT, NEC form of contract or FAC. The fact that somebody's asked you to do something and you've agreed to do a bit of work means there's a contract in place. And in fact, there's a piece of legislation that I'll talk about in a minute, and I don't want to bore people with legislation, law and statute, but this is an important thing. But there's a piece of legislation that says that you can take a dispute to quickfire adjudication being having it determined and decided by somebody and it's binding, even if the contract you have is an oral contract. Just an exchange of words, or even exchange of letters, or an exchange of emails. It's more likely these days, isn't it? Who writes letters?
Yeah, or even a text message.
That the piece of legislation I'm referring to, and some people listening to this will probably be very aware of it, and might not have heard of it at all, but it's a bit of a mouthful. It's called the Housing Grants, Construction and Regeneration Act 1996. Let's call it the Construction Act. That's easier, isn't it?
Okay.
It's a huge bit of legislation. It's rather thick, but the Section 108 in that act says that where there is a construction contract, that under that construction contract, if there's a dispute, then any party to that contract can at any time have that dispute decided by an independent adjudicator. And the decision of the adjudicator is binding. It's binding contractually. Okay, the same dispute might later be gone to court, but whatever happens in that adjudication, if the adjudicator makes a decision, say it's me and you, we're having a dispute, and the adjudicator decides the dispute between us, and he says, I've got to pay you £2,000. Even if I disagree with that and I say I'm off to court to have the same thing looked at, I still have to pay you the £2,000 in the interim. And that's what this act does. It requires somebody to make that payment straight away, even if they don't like it and they're going to challenge it elsewhere. So Section 108 of the Construction Act says that all construction contracts shall provide for disputes between the parties to those contracts to be decided by an independent adjudicator. And then it sets out the mechanics for how it happens. That's it in simple terms. I mean, people ask the question, well, how do I get the adjudicator? How do I start it? And these are things that, of course, we can help with, but the information's out there. It's just Google it to start with, because it's actually quite a simple piece of legislation, simple piece of law, and it tells you what you must do.
And does that allow for, say, for example, if I'm an electrician or a plumber and I do some work for a domestic householder, or is that just B2B?
It's the Act itself is largely aimed at B2B. So that's what it was trying to do. And in fact, it makes a specific provision that if one of the parties to the contract is a residential occupier and the work's being carried out on their home that they're going to live in, then it doesn't fall within the remit of the Act.
Okay.
Now, the kind of exceptions to that. So, for example, and we've seen it, say, for example, somebody was having something built onto the house that was going to be used as an office. That's included. Say, for example, you have a home and it's not your intention to live in it, but to rent it out. That's included.
That's business.
Also, and whereas I said if you don't have a written contract, it still applies. If you do have the wherewithal to actually sign up to a construction contract, such as a JCT minor works form, then the JCT minor works contract has within it express provisions for adjudication. So it's in the contract. So
Brilliant.
There's ways and means around it. But yeah, going back to something you said earlier, if you and I were just having a conversation, you're the builder, I'm the client, and I ask you to do put some new garage to the side of my house so I can park my car, and it's just an oral contract, then in those circumstances you wouldn't be able to avail yourself of the adjudication provisions under the Construction Act.
Okay. And something that struck me as well, because me and you had talked previously, was, it can be very small value. And as you said at the start, it's people's everything. And I think some people might have a bias thinking, I'm not going to go through that whole adjudication process because it's going to take time. It's going to cost me money. And I was blown away by the fact that doesn't actually cost that much money to do this process. And it's very straightforward. And there's kind of a model whereby there's nearly like a conveyor belt system where you guys can sort of triage all these different cases and have people in different areas of the country to, that you can call upon that can, get stuck into these cases and get them resolved pretty quickly.
Yeah, it's the honest truth is that adjudication has been around a long time, in the sense it's been around for over a quarter of a century under this piece of legislation I mentioned. And as a result of that, inevitably lawyers got their hands on it and they made it a bit complicated and made it a bit costly. And it was being used to resolve much more complicated, much more sophisticated and costly disputes than it was originally intended for.
Okay.
And to that extent, some years ago, 2017, the government, through the department, what was previously known as BEIS, B-E-I-S, did a consultation to see, well, is adjudication now too costly that small and medium-sized businesses can no longer use it? And what's the reason behind that? And they discovered that, the cost had increased because adjudication had been grubbed by the lawyers and it was turning into another form of litigation. It's becoming more complex, slow. Lawyers get involved, technical experts. So RSS, along with a number of other organisations, like the Construction Industry Council and members of the Construction Industry Council, like REBA, the architects, and the ICE, for example, got together to look at, well, how can we now re-enfranchise those small businesses back into adjudication without having to change the law? And what the Construction Industry Council came up with was a framework, if you like, for adjudication that complied with the Act. So it didn't mean you had to get a whole new piece of legislation, but was aimed at allowing small disputes to be resolved within 28 days from the start of the adjudication to the end, just as before, binding, and with the maximum payout being £5,000 to the parties, normally split between them. And that was launched by the Construction Industry Council initially in 2020 and updated in May last year. And since then, hundreds of smaller businesses have started to use it. So it's construction adjudication, and it's become massively sophisticated for big, large disputes, being brought back into the arena for small disputes. And RSS, my organisation, is one of the bodies that people come to get their adjudicators. So they say, right, I need an adjudicator. Where do I go? And you apply to RSS, and RSS will appoint one. And those adjudicators will work within that framework to resolve the dispute within 28 days at a maximum cost. It's not a fixed cost, it's a maximum cost of £5,000, which, when you think about going to court, is a fraction of what it costs to go to court.
100%.
Yeah.
100%. Time, energy, away from the business, back and forward to court. It doesn't always get resolved on day one. Paperwork, like 5,000 is nothing in comparison to, what you could have to pay a lawyer to do this for you. And
£5,000, that's just get the lawyer started, isn't it? £5,000.
It is, yeah.
The process itself is meant to be simple as well. So
that's what I was going to ask you. Is it an online, or how do we get to do the complaint?
Well, here's the exercise. I have a dispute with you, and I want to take it to adjudication. So the first thing I do is I send you an email, and in the email I tell you we have a dispute, and I'm going to take that dispute to adjudication, and I have to then say who I am. These are formalities. Who I am, who you are, what the works were, what the dispute's about, and what it is I'm after in terms of a remedy or an outcome. And then at the end I say, and I'm going to refer this to adjudication, and I'm going to ask the Royal Institution of Chartered Surveyors to appoint an adjudicator. That's called a notice of adjudication. And from the day I send that to you, the timetable starts. And I've now got 7 days from the time I've issued that to you to actually hand whatever paperwork I've got to support my case to this adjudicator. But I don't know who the adjudicator is. But on the same day, just after I've sent that notice to you, I get in touch with RSS, email, say, please appoint an adjudicator. Here's my notice of adjudication. And RSS will then appoint an adjudicator within 5 days. Normally, the statutory requirement is that RSS should appoint within 5 days of being asked to make the appointment. But we tend to do it quicker than that. And we also, in that period of time, we undertake due diligence to make sure that the adjudicator we've appointed is the right one for your dispute. So if it needs some sort of legal interpretation of a contract, it might be a lawyer. If it's a technical issue around quantum, then it'll be a quantity surveyor. If it's a design issue, it might be an architect. But within that period, we'll put a round peg in a round hole. We'll make sure the person is properly qualified, but also impartial. So this is not somebody who's biased towards either party. And also that they will comply with this framework that I mentioned, this Construction Industry Council low value framework. And then once RSS has identified somebody, we then tell you and me who the adjudicator is. And then the ball is in the adjudicator's court. Now, I said I've got 7 days to tell the adjudicator what the dispute's about. So what I have to do then is say to the adjudicator, here's my evidence. This is the email that I had from Gavin asking me to do the job. This is my agreement to do it. Here is my unpaid invoice. And any other evidence I might need to provide in order to support my case. And then the ball's very much in the adjudicator's court. The adjudicator will then go to Gavin and say, okay, Gavin, what's your response to this? Let's have a look at what you've got to say. And the adjudicator then decides the procedure, but the adjudicator has to make a decision within 28 days. Now, it's not normal.
I'm going to stop you there, if you don't mind. Sorry for cutting across you, Martin, but yeah. I've received that notice and I'm just going to ignore it. I'm just going to dismiss that because, that guy doesn't know what he's talking about. And over my dead body, I'm going to pay that money. So how do you respond?
So you've ignored it. Doesn't prevent the adjudication from going ahead. So what the adjudicator will do, he'll give you every opportunity to participate in the adjudication and to put your side of the story across, but he doesn't need you to. He doesn't, and so let's face it then, it's in your best interest to participate. In saying that, you might have a valid reason. You might say, well, hang on a minute, I didn't do this work at all. He never asked me. It was somebody else with the same name, that's a good reason. And different company altogether, just got a very similar name. And you've got the wrong guy, mate. That's a valid reason to say to the adjudicator, I'm not participating in this. And the adjudicator in that situation was make a decision, am I going to go ahead with this or not? Likelihood is, actually, Gavin's right, there is another firm, it's very similar name, Gavin Boyle, not Gavin Coyle. And would you believe it, their offices are next door, so this guy's got it all wrong. So he shouldn't have started this adjudication against this Gavin, he should have started it against the other one. So there is an argument there that the adjudicator would look at it and say, okay, yeah, fair dues, not going to do it. But if you are the right Gavin and you just say, over my dead body, I'm not going to pay him or whatever, the adjudication can go ahead anyway. And what the adjudicator would do is give you every opportunity to participate, but he'll still make a decision. And that decision may be, yes, Gavin owes this person money. We'll call it £10,000. And he should pay it immediately. And Gavin's still ignoring it. So what does the guy do? Well, what adjudication has shown over the years is that it's very easy to enforce. And all you have to do is make an application online for a summary judgment. Say, we've had an adjudication. The adjudicator has decided that Gavin owes me £10,000. He's ignored it. And in principle, then, the courts will just simply, as long as they see that the adjudication's happened and it's valid, there's no reason, they haven't got the wrong Gavin, the court will make an order that you pay. And the court will probably make an order that you also pay the costs that I've spent taking the matter to court.
Wow.
And then you can't ignore a court order. You're ordering a court order at your peril.
Yeah. Tenders and everything are going to be affected. Personal guarantees, all that stuff, yeah.
Yeah, you could end up in prison if you ignore a court order. Let's face it. Judges don't like it when you disobey what they tell you to do.
No, but I'm sure that's in that email, that first email or letter to me from you, it would be made very clear that if you don't play ball here and, you know, give your side of the fence, it'll be taken away from you. That gift of you, you know, giving us your version of the truth, of your truth. If you don't use that opportunity, it's a negative for you.
That's a good way of putting it, a negative. Because when you think about it, rather than stick your heels in or do the ostrich thing, put your head in the sand, rather than do that, you participate. You might have a reasonable argument for not paying, but the adjudicator is not going to hear that if you don't tell the adjudicator.
Yeah.
So it's in your interest to either put an argument for not paying or mitigate the amount that's been claimed.
Yeah, because I wasn't trying to trick or put a spanner in the works, but I just get a sense that there's a lot of people who will just put their head in the sand and go, I'm not doing that. I'm not responding to that. I'm not playing ball just because Martin thinks he has one over me. Do you have a sense of, do you guys measure, do you have any metrics that you can throw out in terms of size of companies, type of adjudication awards, you know, in terms of, do you do any sort of data background on your progress in this area?
Well, we do data background on the type of disputes, the nature of disputes. The Construction Act allows any dispute arising under a contract to be determined by adjudication. Any type of dispute arising under a contract. It's a contractual dispute. The value of disputes sometimes is in the millions.
Wow.
But
I didn't see that coming.
No, it is sometimes in the millions. The target audience we're aiming at the moment in terms of this new framework are those people involved in disputes where the value is anything up to £100,000, but anything, you know, down to just a few £1,000s. And what we want to make sure is that people involved in those disputes can use the same process that those involved in multi-million-pound disputes can use, but at a cost to them that is commensurate with the amount that they're arguing about, a sensible amount, and to have it resolved within a short period of time. Since RSS, and to be fair, RSS is not the only organisation that people go to appoint adjudicators. There are other organisations, and dare I name one or two of them. The ICE, for example, the Institute of Civil Engineers, is one. RSCS appoints more adjudicators than all the other appointing bodies put together in the UK. And since adjudication started, we've appointed easily over 20,000 adjudicators on 20,000 disputes.
Oh my God.
Last year alone, 2023, we appointed adjudicators in 1,300 plus cases. And quite a portion of them now, and it's growing, are falling within this low value bracket. Since the low value scheme came into being, we've started to see an upward trend in people using it. And what's interesting for me is, because I've been involved in this adjudication thing for a long time, is over the last couple of years, since the introduction of this low value scheme, I've started to see businesses use it that I've never seen before. You know, it used to be the same old faces, the big companies, you know, the usual suspects, you might want to call them. Now I'm seeing companies using it because they now recognise this is something that works for them. They can afford it. They can, you know, that person who's not paying just because they're not paying, you know, they haven't got a good reason not to pay. We can use adjudication. And you know what? Sometimes even that, you know, that first notice I mentioned to you, this notice of even that is sometimes
Is enough.
just enough to get the person realising, well, I can't ignore this. If it goes to adjudication, I'm going to have to pay the adjudicator's costs and this £15,000 I owe this guy.
Yeah, I'll just
So I might as
resolve
well
it.
just pay it off now.
Have a cup of tea and a coffee, and let's just get over it. And
Just get over it. Get it out the way, yes. I can't ignore it.
no, but a massive part of the podcast, obviously we speak to the one woman in the van, tradesperson, working mad hours, tradesman first, businessman or businesswoman second. And, we're trying to give them as much information because they don't have time to go back and sort of go to night school or whatever else to sort of pick up some of the stuff. And so it's great to have people like yourself coming on the show, because it's a show that when people are going on the way home, that they can listen and go, all right, I'm doing that. I'm going to now I've got good verification. I need to do more of that, or I'm not doing that. And I think the more we can get the message out to people that this is a real game changer in terms of the amount of people that are suffering at the moment by not being paid in the construction industry is staggering. And I'm getting a lot of feedback from our listeners about, horror stories of not being paid and losing the mortgage and losing the family, and suicide and mental health and all this kind of stuff is being affected by it. And I'm listening to you and I'm saying to myself, I'm grabbing your model in whatever way I want to put it into my words, but I'm going to put it in my terms and conditions that's subject to any sort of issue with me and you. Let's agree that we're going to go the Martin Burns route of adjudication. And I'm kind of joking on that, but like definitely, it's an easy lift just to copy some of the text and put it into your terms and conditions and say, look, let's agree that we'll go down this route if we can't agree.
Well, you don't have to agree, in the sense that if you have a B2B contract, and that B2B contract can be with a residential occupier as long as the work's not related to the property they're living in, you don't have to get agreement. The law says that you can do adjudication without the other party having to agree to it. So you start, and that can happen with an oral contract just as it can happen with a written contract. So as long as the contract is for works which are described as construction works under a construction contract, i.e. they're not solely about works carried out in a residential occupancy where one of the parties is going to live, then you can instigate adjudication, whether it's an oral agreement or whether it's a written agreement, without getting the other side to have to agree to it. You don't need their agreement. That's the beauty of it. And the way the Act, Section 108 of that Act legislation is worded, says that a party, not both, a party to a construction contract can start an adjudication at any time. So they don't need any agreement. They don't need any sort of preamble to it. They just start it at any time. Here's another little low-hanging fruit to add to all of this. During the lockdown period, the government were very concerned that small businesses would really struggle, and that those who needed that sort of cash flow in order to maintain their businesses and get on to the next job would really, really suffer as a result of not being paid. And so RSS, the organisation I work for, not only supported the use of this low-value adjudication, it introduced one of its own, which was aimed at disputes where the sums were really small. And again, I don't want to be rude when I say really small. I mean £20,000 or less, down to just a couple of thousand. And that could cost people more or less nothing to have it adjudicated. It's called summary adjudication. Again, it's backed up by this legislation, so the other party can't ignore it. And it can get a dispute resolved within 14 days. It's even cheaper than the £5,000. And as I say, in some circumstances, it might not cost anything at all.
Wow. And wow.
And it's just as effective. It has all that backing of the law to make it happen.
When did that come into force?
We brought that out right at the beginning of the COVID lockdowns, when in my job I talk regularly to people in government departments and all sorts, and they gave me a sense that one of the big issues they have is this concern now because of lockdown, because of the way the environment's changing, that a lot of small businesses are going to suffer. What can RSS do about this? And so I worked with colleagues at RSS and others to say, well, shall we see if there's anything we can do to actually make that low value adjudication even more accessible to those who are involved in the lower end in terms of value of dispute. And we brought that out first lockdown was March 2020, and I think we brought it out just a couple of weeks after the first lockdown. And that's been used. That's used regularly as well.
But which begs the question: how is your company's or your organisation supported financially? Like, you're not for profit. Where does the money come? Because these adjudicators can't be cheap.
Well, the first thing, the Royal Institution of Chartered Surveyors is a professional regulatory body for chartered surveyors. So I'm a barrister. My regulatory body is the Bar Standards Council, and I pay a sub to them every year. Doctors pay the General Medical Council a sub every year. Chartered surveyors pay RSS subscriptions every year. So the main basis for financing the Royal Institution is through subscription base for its 140,000 odd members throughout the world. The department I work for, the Dispute Resolution Service, it actually makes money. One of the things we do is we charge a small fee for every appointment we make. So if you want somebody to appoint under that summary judgment scheme I mentioned, I think that's about £100. That kind of pays our admin costs on there. The people who act as adjudicators that we have on a panel, they're trained and they pay for that training. That's another source of revenue. There's people on, I talked about some of the larger disputes, multi-million pound disputes. There's people, maybe a bit like yourself, Gavin, who are professional people who act as their advisors and their representatives. And they often need training in order to do that job well. And we get paid from that. So altogether, we have various revenue streams through training, through education, through administrative fees for making appointments. Also, we're not just involved in the construction side. We actually provide dispute resolution right across the built environment. Property, land, anything from telecoms to compulsory purchase, not just in the UK, but internationally. So we're operating in Australia, Canada, New Zealand, India, Africa, Europe. And all of those things together generate revenues, which mean that the department I'm involved with, we're very much self-funding. In fact, we also make a contribution to RSS funding.
Okay, yeah, no, I knew you weren't a not-for-profit, Martin. I was kind of being a little bit cheeky about it, but it's phenomenal. To be able to provide that service, and I just get the sense from the construction industry that people need to be. They're probably not as aware as they probably should be about the service. Do you feel that there's a sort of a brand awareness or some sort of a disconnect between this type of service that's sitting there for people, or are you feeling that it's growing and it's getting momentum?
I absolutely feel it's getting momentum, particularly in the last couple of years. And let's call it the COVID effect to a certain extent as well, because we now have very solid relationships with other organisations who provide similar services, but also with the government. And the government has been tremendous in the sense that it recognises the importance of the construction industry to the UK economy.
Yeah.
So post-COVID, post-Brexit, the construction industry represents something like 10% of the UK's GDP.
Yeah.
And in recognition of that, the construction industry and those who are in charge in government, whether it's Conservative, Labour or whatever, this is an apolitical situation, are all supporting anything that drives greater efficiency and greater effectiveness in the construction industry. And that includes reducing the amount of disputes which cause delays and cause additional costs and cause people headaches.
And not just that, it's clogging up the court system with stuff that could be resolved in a more, reasonable sort of environment, subject to having the right structures around it, which you guys obviously provide: the structure, the manners, the discipline, the transparency. So, a lot of people go to court and they don't really know where they are in the process with the legal teams. They're just like, we'll get back to you whenever we need you, kind of a scenario. Whereas what you've explained today is a very, very sort of, what the sense I got from it was, there's very little friction in your process. It seems to be very smooth and sort of like something that can just be easily, I'll put that right into Martin's lap, and I'm just going to get on with my business and making money. No, but seriously, like, that's what people want in, I suppose, in the segment that you're targeting, that we spoke about today, which is the SME sector. They don't have time, and I think that's probably what's something that most of them switch off and go, I know I got burnt on this, I'll just make it up on the next job, and I'll just take me hit.
Well, that's the choice people make, isn't it? If you have a dispute where you're after money, you believe you're entitled to money, the choices you have are you just drop it, or you try and make it up on the next job, or this is so important to you, you feel you need to fight because you're in the right. Now, as you say, Gavin, to do that and go to court, it's just not worth it unless you've got a real big dispute and you've got lawyers to back you up and you've got the money to pay for it. What adjudication and what the simple low-value adjudication process allows is for somebody who hasn't got all that resource behind them, hasn't got the ability to pay lawyers, to have a method of resolving that dispute that is quick, effective, and gets the money, if they're entitled to it, of course, quickly, without having to have a real depth of understanding of legal process and that kind of thing. This all came about, this adjudication, back in the 1990s because of a recognition that people needed to be able to have a method of resolving their disputes that could be used on simple, straightforward, bite-sized chunks that didn't need huge input from lawyers and wasn't going to spend years and years getting to the bottom of.
And with that, I'm going to throw a curveball at you, if you don't mind, Martin.
Great.
So people are probably sitting, listening to this podcast on the way home and going, those two guys, I don't think I'll go for a pint with those two guys. They're just...
Yeah. Because they'll end up paying.
So I'm going to shed a bit of put a little bit of a curveball on it. From time to time, we ask people some odd questions just to get to know more about the character. And
far away.
I'm going to ask you some random questions just to sort of, take our mind elsewhere, away from the whole legal, not getting paid, having a bad day experience. And if I was to say to you what your favorite book is, what is it and why?
Sadly, I read a lot. I always have 2 or 3 at a time.
Wow.
If we're talking to the guy driving the van, then I'm going to tell you about a book I'm reading now that I have to keep putting down because every few pages I'm laughing my flipping head off. And people have probably seen that television program, Vic and Bob, is it Bob Mortimer and Paul Whitehouse, the fishing thing. And Bob Mortimer, he for me is one of the funniest men I've ever come across, and he's written a murder mystery called the Satsuma Complex. Now, I'm not saying it's my favourite book of all time, simply because I haven't read it yet. I'm only about a third of the way through. And I've been at it for a few days now, and I'm struggling to read it because it's making me laugh so much. And if you wanted me then to go on the other side and be serious,
well, sorry, what's the thesis in the book?
The thesis in the book. There's a guy called Gary, and he works for a legal firm. And he goes out for a drink with a private detective who does a little bit of business with the legal firm now and again, on divorce cases. And he goes to the pub. He doesn't like this guy at all. And he describes this guy as somebody you wouldn't like, I wouldn't like. But he's in the pub having a drink with him. And to his massive release, the guy takes a phone call and says, "I've got to go." And he leaves our Gary alone to have a drink and try to chat up a woman quite unsuccessfully. Anyway, he gets up the next morning, 2 police come round, and they tell him that they want to know what he's been up to. They tell him eventually that the guy he had a drink with was found murdered.
Okay.
Now he's got to find the girl that he tried to chat up with because she's his alibi. Prove he didn't do it. But, he talks to a squirrel. He goes along to the local park. He sits there and he's constantly talking to this squirrel. It's just so funny. The sort of questions he asks as well, the rhetorical questions. Like, have you ever had a job where you've had need of a tourniquet? What? Believe me, I'm not giving a good account of this book, but it is immensely good, immensely funny, and
it's going to sound like a dry wish, is it? Kind of a dry wish.
It's a surreal wit. Bob Mortimer. For those who are listening and that know of Bob Mortimer, they would know that he was part of a double act with Vic Reeves and Mortimer, and that their humour was a bit off the wall. But he is an immensely talented writer as well. He's not stupid. He was in real life a lawyer before he went into show business.
Okay, interesting.
He's an all-round nice guy.
If I was to ask you your favourite holiday destination and why?
Oh, some people are going to like this. The easy answer to that is beer.
Your favourite holiday destination?
Yeah, okay, I'll explain.
Go for it. I'm intrigued.
But my wife's parents live in East Devon, near to a village on the coast, a beautiful village called Beer.
Come on.
It's a lovely, lovely village on to the Jurassic coast. It's the scenery and the sights are absolutely wonderful. And it also, of course, has wonderful pubs. And one of the pubs is called the Barrel of Beer. And I've often text friends from there saying, I'm in beer, drinking beer in the Barrel of Beer.
Brilliant. That's brilliant. My father had a pub at one stage, and it was called the Mayfly because obviously there was a lake nearby, and it was the only pub that was, and all the fishermen obviously went to the Mayfly pub. But the running theme in the pub was, you may fly in, but you won't fly out.
Oh, I love that. Yeah.
Tell me about what car do you drive and why? This is the last one. I'm not going to give you any more awkward questions, I promise.
Oh, it's a boring car, but I love it. It's a Nissan Qashqai. It's my third Nissan Qashqai. I had 2 before it. Reliable, spacious. The thing is, I bought this one new a week before Christmas, and I parked it at a shopping centre car park. Had it a week, and I came out, and there's this oldish chap looking very distraught in the car park, and he saw me coming towards the car, and somehow he had managed to open his door and wedge it into the gap not between my door and the stanchion, but the handle that opens the door and the lock.
Yeah,
and he got it caught between how he managed to do that, and
random.
And why he was looking distraught was not only did he manage to get it caught somehow in my door handle, but he got this huge big guy from Halfords in the shopping centre to come out and try and help him. And this guy from Halfords thought the best way to do it was to start rocking my car. And what did he do? He tore the door handle off.
Oh no!
So I've got a Nissan with a missing door handle. That's what I have. Is the answer to your question.
Brilliant, Martin. Tell me, people are going to be scrambling onto the laptops, looking to get in touch with your organisation. How's the best way to get involved or stay involved? Like, obviously people might be listening to it and going, good to know, and sure, I'll pick it up in the future. But I think it's something that people should have in their directory or some sort of in their favorites of, social media channels or whatever else that they're constantly getting updates on news within how you guys operate. Tell me how the communication should work from after the show with yourselves.
Well, I think the first thing, if anybody's interested in anything I had to say, then Google is wonderful, isn't it? And I Google low value adjudication, and that will bring up a lot of the information that I've talked about in terms of that process and how to access it. My organisation has its own website with pages dedicated to the work I do, and that's rss.org and /DRS. D for dispute,
Okay.
R for resolution, and S for service, so DRS. And that should bring you to a lot of the information, contacts and everything else. But there's a lot of information out there on the kind of work that we do in avoiding, managing and resolving disputes in construction. And, if people are just sitting in the settee and there's a boring thing on telly, just get your iPhone and start looking.
No, I wouldn't dismiss, to be honest with you. I know there is a lot of information out there, but again, people kind of get saturated with stuff and then they kind of, where's the real value? Which is the one that I need to sort of zone in on? And your one is the one they need to zone in on. And I know that you've kindly given us a document as well to share with the audience, which we'll put in the show notes. And we'll also put links to your website. 100%. I think the information you've given today is immeasurable in terms of what and where the industry is at the moment in terms of risk management and the risk profile of people getting damaged by not getting paid. And I think it's a credit to you and your organisation, and kudos to everybody, including yourself. You're doing a brilliant job at explaining how easy the process is and how accessible the process and the connection to make between you and the distressed parties, obviously. And I say parties rather than it coming from one person, that two people, there's always two sides to every story. And I think that's a big takeaway from today's podcast. And Martin, it's a credit to you and well done. I'm delighted you came and had a talk with us today on the subject.
Thank you very much, Gavin. I was delighted to I've enjoyed it too.